It's a dramatic opening slide, but I want to be clear about my message from the outset. The root cause of many of our regulatory problems are licensees' willingness to embrace simple black and white responses to nuanced issues. It's embedded formalism, bureaucracy and risk aversion. Our tendency to ask, can we, instead of how can we, has, as Commissioner Hayne recognised, also delayed the emergence of a legitimate advice profession. I'm Sean Graham, Managing Director of Assured Support, and I want us as an industry to move beyond stark and simple defaults. I want to help you see more. I know it seems a little trivial to be talking about compliance in the current environment. We're enduring an implacable pandemic, managing an economic slowdown and struggling to reconcile increasing compliance costs with declining margins and a more active regulator. We can see far enough down the road to anticipate what the Royal Commission will deliver. We see the law firms and litigation funders circling the larger institutional licensees, and every day we're seeing how look-back provisions have been weaponised against advisors to spare controlling entities any embarrassment or censure. We're lucky enough at Assured Support to work with some incredible businesses, so I want to offer a prescription for success they routinely demonstrate. Ignore any opinion that has been drafted purely from a technical perspective. Dismiss legalistic approaches that don't explicitly consider the principles and the environment in which those principles operate. And sideline advice that doesn't explicitly consider your people, your compliance arrangements, and your culture. To be clearer, you need to more critically consider the compliance advice your lawyers, compliance people and advisors provide you, and make your own informed decisions based on your knowledge, your risk appetite and your understanding of the law. Engage experts, but don't automatically substitute their judgments for yours. When I recommend that advisors and licensees make informed decisions and back their own judgment, I'm not dismissing the value of expertise, quite the reverse actually. But I suspect that some of the problems we're facing now are because we've seen everything in black and white terms, absolutes and assumptions, instead of recognising and adapting to the grey. There are some unambiguous requirements, but the law and the regulatory regime is flexible and can accommodate a range of options. Unfortunately, for a range of reasons, licensees and advisors seem to have little appetite to navigate the grey. Even in a consumer-focused world, there's considerable commerciality and flexibility available to advisors and licensees. There's an opportunity in these areas, particularly those spaces where prescription and certainty haven't yet replaced outcome-based rules. This is the opportunity institutional licensees traditionally avoid. Just to be clear, we're not endorsing avoidance strategies. We're not advocating client protection policies or promoting personal advice models dressed as general advice. We're simply suggesting that, whether you're an advisor or a licensee, you have more options available to you than embracing over-disclosure, safe harbours and regulatory conservatism. Safe harbours provide shelter, but they inhibit innovation. If you're going to navigate the grey and avoid the regulatory reefs, you need to have the courage to leave the harbour and the knowledge to understand the currents and swells, and that might require more from your lawyers than they can provide. Of course, your lawyers might be neither conservative nor risk averse. They might well have the practical experience and industry insight to help you, and there are some excellent lawyers that do and some excellent lawyers that I can recommend, but I maintain that in most cases, you shouldn't automatically substitute their judgment for yours. It's your business, it's your risk and it's your decision. The other important point is that the original legislation didn't have a safe harbour. The concept is a direct consequence of big licensees seeking certainty and demanding prescription. The mortgage industry, in contrast, has a best interest duty with no safe harbour. As a matter of fact, RG 273 expressly states that nothing in this guidance is intended to provide a safe harbour. So why don't we have the same freedom? Before I incite you to regulatory revolution, I want to briefly explain who I am and what Assured Support does. I'm a financial services lawyer, compliance specialist and an author. I'm also the founder of OpenAFSL, a specialist RegTech platform. I've had a variety of compliance, legal and management roles, including roles at institutional licensees, an association, a mid-tier law firm and Australia's most popular comparison site. I've held directorships on advice businesses and been a responsible manager on a number of licenses, so I understand. Assured Support itself is a small but growing independent consultancy that provides advocacy, compliance, governance and risk management support to a number of clients, including licensees and advisors. We're compliance nerds because we understand what compliance really is and the significant advantages that comes from getting it right. But we're not the regulator. Our mission is to help our clients feel safe and see more. We're also very active. We try things and we're very data driven. We see more, so when I'm addressing industry topics, I'm doing it from an informed position. We've worked with over 100 licensees of various types, and since 2012, we've reviewed almost 8,000 client files. We frolic in the grey. We immerse ourselves in our client's business, their reality, their risk framework and their appetite. This equips us to see more and to move beyond black and white. We've also been involved in some interesting regulatory matters, not all of which we can talk about. But as we address this topic today, I will be drawing on some of those experiences, including my incidental involvement in National Sterling, to my reviews of wealth and risk management and Financial Circle. When I suggest that you shouldn't necessarily let your lawyers decide for you, it's not for any other reason than my belief that over-reliance on legal and compliance advice is a significant reason why licensees aren't responding to the relief and encouragement ASIC provides. I appreciate that suggesting ASIC is anything other than obstructionist, destructive and reactionary won't be popular, but they're not entirely to be blamed for our current situation. The financial services laws were principles or outcomes focused, but became, over time, both prescriptive and restrictive. That's a legacy of institutional advice models. As Commissioner Hayne recognised in his final report, sometimes the requests for prescription and detail seek to shift responsibility from the regulator to the regulator by urging the creation of safe harbour provisions that leave the regulated entity with little more than a box-ticking task. This is where we are now, but I'm optimistic that we can reverse this trend. Change will require intellectual drive, honesty and rigour, but more importantly, it requires leadership, self-discipline and self-regulation. It's embarrassing that the Royal Commission had to remind us that the primary responsibility for misconduct in the financial services industry lies with the entities concerned and with those who manage and control them, their boards and senior management. If that's not enough of a wake-up call, appreciate the irony of ASIC observing that licensees' statements of advice met the regulatory standard but were not compliant enough to satisfy their own legal teams. Unfortunately, the problems aren't just theoretical. This is the real problem, but honestly, is it any wonder that advisors are scared and apprehensive? Quite apart from the weaponisation of the look-back provisions, there are a number of advisors' failures that I think are directly attributable to their licensees' conservatism and abdication of responsibility. This has led to dense and often incomprehensible advice documents, requirements that fail to differentiate between internal policies and legal requirements, and lookbacks often undertaken by unqualified and inexperienced persons with little or no practical knowledge. It's a scary environment to operate in, but less as a result of the law and regulation than licensees' inability or unwillingness to understand their opportunity. There are, to my mind, three reasons why advisors and licensees are afraid not to challenge black and white solutions. These are complexity, consequences, and comprehension. Now, it's pointless to pretend that financial services isn't complex, complicated, and open to interpretation and reinterpretation. It is. It's a confused mess of principles and prescriptions that reflects legislative overreaction to an industry struggling towards professionalism. Commissioner Hayne observed that legislative schemes have commenced with principles at the fore, only to have the full suite of prescriptions grafted on over time, and that's our reality. While simplification might not be possible in the short term, we can choose to better navigate complexity rather than simply surrendering to it. Depending on how you deal with complexity, it has a flow on to consequences. Let me be clear. When I'm talking about consequences as a barrier to professionalism, I'm not just focused on the sometimes disproportionate penalties for non-compliance. As important is our tendency to overestimate the likelihood of regulatory and legal risks. This contributes to pushing us from prudence to paralysis. It also leads to more cynical and less honest approaches. In some cases, licensees embrace the form of well-governed businesses, but without the substance. They also consume legal advice as insurance and, you might argue, to shift liability. Financial Circle, for example, had policies and a comprehensive compliance manual bought from their lawyers, but it was generic, incomplete, and it didn't just match their business. It was, in some ways, worse than nothing. Likewise, David's pursuit of their lawyers over their client protection policy could be interpreted as nothing more than a cynical attempt to distract attention from their own choices. Fixing your vanilla generic compliance arrangement starts with understanding your obligations. If, for a moment, we consider how formalism, complexity and conservative impacts clients, this is the best example. It's a common theme of the cases I referred to earlier, but it's certainly more widespread than we might be comfortable admitting. The outlier cases like NSG and Financial Circle aside, we are seeing good advisors failing to act or show that they've acted in their client's best interests because of the licensee's requirements. Their poor compliance arrangements are in fact shackling their advisors to suboptimal outcomes. Some licensees have embraced the principles of these duties, but also shackle their advisors to audit design checklists. Again, I accept that advisors have agency, but I also understand the cost of an authority. Most advisors are not well equipped to push back on their licensees, but they ultimately bear the brunt of the licensee's choices. Thankfully, many of the new licensees that are emerging from the rubble of institutional models understand this cost and are actively challenging, or at least exploring, the assumptions and misconceptions they've inherited from their predecessors. So how does poor legal advice manifest itself in some of the licensees we've reviewed? And when I talk about legal advice, I'm including all the compliance and risk management people that support advisors and licensee. It's not uncommon to find that licensees are relying on boilerplate compliance manuals and processes, all well disclaimed, that don't accord with the structure, nature, scale and complexity of the businesses relying on them. We routinely see small businesses struggling to comply with risk management plans borrowed from institutional licensees. We see, for example, internal meetings formally held and minuted, but don't identify obvious themes or follow-up actions. We also see templated documents, financial services guide, statements of advice and service agreements that appear to be written by a technical committee and approved by the Politburo's least imaginative lawyers. Documents that miss the opportunity to engage clients and improve the client experience. They are compliant if compliant is a euphemism for dull, disengaging and bureaucratic. Now, based on our data from 2019 to 2020, 25.73% of advisors failed to meet minimum legal requirements. That seems like a bad result, but it's not entirely fair to blame the advisors who, in many cases, are simply following the directions of their licensees. All the issues we've identified here come back to licensee decisions. And these failures are particularly obvious when we consider the best interest duty. Licensees and advisors have relied on signed-off documents and disclosures, but disclosure can also lead to problems of moral licensing, where the act of disclosure frees the advisor from the obligation to comply with the norms of their profession. As Report 632 proved, disclosure creates additional problems. Simply put, by disclosing duties and conflicts of interest, for example, an advisor becomes less concerned about the partiality or the motives and the intent of their advice. In a perverse and paradoxical fashion, disclosure seems to shift the advice relationship from one of trust and reliance and asymmetric knowledge to one of equals, where the client is fully responsible for the choices they make about the advisor's recommendation. Now, recent examples of best interest advice include recommendations that, for example, immediately reduce the superannuation balances by over 40%, push the client into more expensive products, justified replacement of products on the basis of obtaining additional benefits that were already present in the existing products. In some cases, the advisor charged fees that were so significant that the client would take almost 4 years to return to their pre-advice position. Other advisors, complying with their best interest duty, rationalised cookie-cutter advice on the basis of efficiencies that benefited the advisor more than the client. We've seen advice that delivered self-managed super fund recommendations and limited recourse borrowing arrangement recommendations to clients who had no adequate income or real capacity to service the debt. We've seen other best interest advice that used fanciful projections of possible savings being preferred over the demonstrated ability to save, reduce debt or eliminate regular reliance on short-term credit. In these cases, the best interest duty was misunderstood or misapplied as a result of the compliance obligations put in place by the licensee. So the problems and their causes are clear. Thankfully, the solutions are equally obvious. First, return to first principles. The first step you need to take is to step back from formalism, from black and white solutions, to focus on the principles that guide your activity. Remember, both FASEA and Commissioner Hayne have urged you to step away from box ticking and embrace principles over prescription. For the Commissioner, a professional advisor should simply obey the law, not mislead or deceive, act fairly, provide services fit for purpose, exercise reasonable care and skill, and act in the interests of their client. Hayne observed that one of the necessary aspects of a desirable culture is adherence to the basic norms of behaviour, and we need to return to those. Perhaps, in fact, it's time for you to relax your compliance arrangements a little. It may be an unpopular position to advocate to licensees, but as Anna Bernasek concluded in The Economics of Integrity, a system that tries to eliminate wrongdoing tends to restrict activity. But rules that set people free to do the right thing rather than holding people back encourages more activity and creates wealth. Second point. Focus on the environment. The bad apples technique is a popular one for licensees averse to accountability, but it's important to understand that personal preferences are the smallest and most insignificant component of misconduct and non-compliance. The environment in which your advisors operate, your culture and your compliance arrangements are more critical components. 3. Choose better people. Engage the right people to help you. These should be lawyers or legally qualified, but they will need the breadth of capability and insight, and they'll need to bring more than a legal view. They'll need to bring into your business insight into regulatory matters, corporate governance, compliance, and risk management. Now, it's important to understand that lawyers are often risk averse, particularly in relation to their reputations, and they'll often use technical expertise to disguise a lack of practical understanding or their dearth of experience. Watch out, because they'll often answer the question you ask rather than your underlying question. And they'll often answer questions without pushing back on appropriateness and without stepping into an executive role. So it's important that you find the people that know, understand, and separate can from should. You should also encourage dissent. Hire people that can and will step into the broadest, traditionally non-legal areas of conduct and culture to ensure that their advice and insights are valuable and relevant. 4. Elevate compliance. So moving beyond a black and white solution requires more than a willingness to do so. If you've recruited the right people, people with the capability and insight to support you and your business, you need to empower them to do so. Don't relegate them to a back office function, but utilise them effectively to grow and protect your business and your culture. The 5th requirement is you need to choose to be brave. Now, when the regulator chides us for our conservative and risk aversion, it's a reliable indicator that we've got tremendous opportunities ahead of us. We just need to decide how we want to interpret the law and how comfortable we are doing so. So where should you start? Okay, practical steps. Start by reviewing your risk appetite. Look at your tolerance and your willingness to engage in all levels of risks. Then review your audit templates. Audit your SOA templates. Now, when you're looking at your statement of advice, it's important to look at it from a customer experience perspective as well as differentiating between the law, regulatory policy, licensee policy and habit. If you're not part of a vertically integrated banking group, take the time to review your risk framework for clarity and engagement. I'd also suggest you reframe your manual and make sure that it actually reflects your business. And the 5th and most important point, and I'm emphasising this for dramatic effect, is engage people that are willing to understand your business, your compliance arrangements and your risk appetite. That is the essential source to solving these problems. I'd like to thank you for your attention. Now, remember that while managing your regulatory risk is a dangerous suggestion in many ways, an advice profession is unlikely to emerge from a trade comprised of people who are scared or are ignorant of the laws that surround them or are unwilling to exercise their own professional judgment. We need to drive the emergence of an advice profession. Now, I've linked some relevant material to this presentation. If you have any questions, please don't hesitate to contact me.